evening, y'all.
Good
Hey.
evening.
How you doing? How y'all doing? Um, okay, I'm gonna go by who I got on the list. Carrie, is that Carrie Watkins, Chrisman? Carrie, hello. All right. Daniel Moore, I see you up here. Daya Hilliard.
Here.
All right. Janera Harrison.
Here.
Reimer. See you, Joseph Reimer. Carrie Daniel. Daya. Janera Harrison. I'm just calling names in order now because now everybody's signing in. So hold on. All right. All right. Amari Yassine. Nope. Couture artist. Nope.
I'm here.
Oh, you are. Oh, I'm sorry. Wait. Oh, you here? Oh, I'm sorry, Amari.
That's Yasin talking.
Amari Yassine. Okay, I got you.
Yeah.
Okay. It's opposite. That's why I can't see it. Yeah. Okay. Couture artist. Zaria Ashley. Zaria. Nope. Nadia Bell. Nope. Jalen Brumby. Michaela Cleveland. I think I saw you sign in. Michaela Cleveland.
Yes, I'm here.
Larry Colbert. Don't see Larry. Ayana Collins Roberts. Nope, don't see you. Maya Cross. Is that you?
Here. Yeah.
Marius Davis. I see. I thought. Yes.
Here.
All right. Jay Downs. Nope. John A. Harris. Don't see. Okay. Already got Janera Harrison earlier. Xavier Hayes. China Hazel. Nope. I got Daya Hilliard earlier. Shanique Hines. Are you here? Yep. Okay, I got you. No Justice Hope. Antoniqua Hubbard. Nope. Cameron Ingle. I don't see Cameron in here. Nope. Willie Lennon. I think I see you up here.
Yeah, right here.
All right. Kyla Lofton. Not seeing that name up here. Nope. Skylar McDowell. Nope. Shadeja McMillan. Mm-hmm. Oh, here's Kyla Lofton now. So I got Kyla Lofton signed in now. LaStacia Miller. Jermaine Mitchum. Nope. I got Daniel Moore already. Miss Philomar. See you up here.
Here.
All right. Patrick Price. Kaylin Red. Nope. Parrish Rippey. Nope. Got Joseph Reimer already. Akeem Sirleaf. Nope. Ratia Taylor. Nope. I got Kerry Watkins already. Tavis Williams. You there? Tavis. Tiana Williams. I got Miss Hubbard coming in. I got you. Who else came in late? I got you, Kyla Lofton, as you were signing in. And who else you signed in? Hubbard. We got Hubbard in here now, so we're good. And I think that's it. Anybody I miss? All right. Okay, not too much to talk about tonight. Tomorrow, the last chapter in the book will be that lecture, chapter 13, will be posted in the morning, so that you pretty much will be done with the textbook, all the learning from the textbook. What that means is we're gonna have next week we're gonna have a Zoom on chapter 13, talking about chapter 13. And then the quiz is going to be up that next day, that Friday. So you do have a quiz next Friday. It's gonna be up next Friday through like Monday at 11:59. So I won't let you guys. I got at least 15 of you on this call, and that's not half the class, but got you guys on here, so do be reminded that there is a quiz that'll be up next week. So it'll be up to date after we talk on Zoom. So that following morning it'll be up. So we'll talk more about that quiz when we get to it. I just want to let you guys know it's coming for the syllabus. So anybody that has a syllabus, if you have it printed out or look at it, you'll notice that everything is exactly how we planned it. So I'm not deviating from the syllabus at all right now. There's really no reason to deviate. So we're good. For this evening, we talked the last chapters you guys read on and that I lectured on. It was chapter 11 and 12. Before I talk a little bit more about it, let's see, Larry Colbert signing in.
Professor Voice, did you get me?
Who's this?
Tavis Williams.
Yeah, I got you. You. You didn't respond, but I saw your name in the.
How you doing, Professor?
How you doing? I got you, Larry. I just saw you sign in.
I appreciate you, boss.
All right. What was I saying? Okay, so before we talk a little bit about chapters 11 and 12, are there any questions whatsoever? Were my lectures clear? Did you understand what I was talking about? Everybody good? Okay. Of course, we've been in the book primarily. We haven't talked about any kind of case law. Coming up after next week and after the quiz next week, we're going to start jumping. That's when we get outside the book. So after next week, so next week will be the 23rd. You got that quiz is going to be up on the 23rd through Monday the 26th at 11:59. There's another discussion. After a quiz that following week, we're not planning to meet, so we don't necessarily. So I'll sign on. I'll sign on just to be here in case you have questions, but there's not a planned meeting on the Thursday at that's following a quiz. So you have a quiz that'll be up Friday through Monday, and that following Thursday, we won't meet, but there will be a discussion board. So please, everyone's been having problems this semester. I realize this is different, right? So normally we will be meeting, I always teach evening classes. That's why I have my class, why we meet at 6, because if we were in class right now, instead of being virtual, we would be in a classroom right now at 6. I teach evening classes. So that's why I plan my Zoom sessions for that same time, for the same time frame I would normally be in class in person. I know it's different because, of course, I'm not tangible right now. And I'm in front of you in real time right now. But the semester is different when you have a professor that's in front of you, talking to you and lecturing to you, and essentially on you to remind you. The hard thing about this virtual learning is the fact that you don't have a professor that's in your face every week. So what makes it hard and difficult is not necessarily difficult. It's just something you're not used to. Is now you don't have a professor to get on your nerves once a week in person in a class to tell you this is due or that's due. So and normally we will review or talk about stuff because we will meet in class anyway. So the problem I'm seeing with students in all my classes, because I teach 4, is students aren't up on the syllabus. So I literally designed everything this semester for every class so that everything would be exactly as it's planned on the syllabus. So with this being a virtual classroom culture now, the syllabus is very, very important because that's all we have to go by. I don't know about other professors, but if you're in my class, everything's by the syllabus. I literally worked my behind off early on to plan everything, recording lectures, making sure everything was dropped at a specific time and everything was due and everything was available to you guys at a certain time. So if it's easy for you, it's easy for me. So I've designed it that way, but it's only easy. It's not really hard at all. There's nothing difficult about it unless you make it that way. So I suggest you guys print the syllabus out. I think a lot of you are trying to be straight up virtual. I got it on my phone, but you're not looking at it. So I've had quizzes and stuff like discussion boards up, and people just all together forget to take it and just don't do it. One of the reasons I can't be a jerk right now, and just say I'm not posting it, I'm not extending the deadline, is the university may get mad at me because because we are in the pandemic. People that aren't showing up for class that I don't see, if I email them or whatever, they don't get back to me. I really I don't know what their health situation is, right? So I can't be out here just flunking people and doing people dirty because honestly, I don't know what the health situation, I don't know what their personal health situation is. They could be sick or someone in their family could be sick. There have been deaths and stuff, so I understand that. That's why it's important because things are different. Need you guys to, it's important. I know we don't want to kill trees. I'm on the Solid Waste Commission. I believe in environmental stuff, but y'all need to print the syllabus out. Just go ahead and kill the trees. It's just 2 or 3 trees. If all y'all print out a 4 or 5 page document. As you see, I'm calling the roll and I'm marking it off, but also I'm the professor and I have a copy of the syllabus. So literally I'm marking off what we're doing as we're going. I think if you guys do it that way, we'll have less problems with you forgetting things. So if you have the syllabus printed out, and honestly, I know you guys might see the pattern, but if you notice, nothing is actually ever due on a Thursday, right? Thursday is just for me to talk to you on a Zoom. Anything that is given to you that's new, or a reading assignment or a new lecture, if you notice, it comes out always on Friday. Our quizzes are always on Friday. The discussion board is technically that's the only thing that comes out on Thursday, and that's pretty much replacing. The discussion board is pretty much replacing our normal Zoom discussion. So if you notice, the rhythm in this class, and that's why I designed it a certain way. If you notice, nothing's due on different days, right? is we always meet on Thursdays or something on Thursdays where me and you interact, either by us talking on Zoom or by you joining the discussion board, or on Fridays is always where a quiz where a quiz is gonna be dropped, if it's gonna be dropped at all. So I designed it that way because I want you guys to have a rhythm. Voice on courtroom testimony and voice Thursday and Friday, and I'm done with them. So I designed it that way so it wouldn't be jumping all over the place because I know that would really give you guys problems. So I've designed it. I literally designed it so it will be easy so you guys can get into a rhythm with me. I don't know what your other professors are doing, but that's how I designed it, and I'm hoping you guys appreciate that. Do you? Anybody got something?
Yes.
Okay. So I'm trying to do it that way. So I need you guys to key in, because I'm trying to be your easy professor. This ain't the hardest. This should not be anywhere close to the hardest class you had this semester. So I'm trying to make sure. So whatever you do, I don't want you guys to make the easy things hard. Don't. I call it snatching defeat from the jaws of victory. If it's a class like this, it is supposed to be easy. Don't make it hard. And you make things hard and you put yourself in a hole by not staying on top of things. So stay on top of your syllabus. So that, I'm gonna remind you as much as possible anyway. And I know I know I'm kind of being a bugaboo, but I gotta be that way. I'm the old man, I'm your daddy, right? Or your uncle. They're always get on your nerves, tell you to get up and do this and do that. That's me right now. I have to be that way. Because I don't want to give anyone, I don't want to have to give anyone a bad grade. So I hate doing that. I'll do it, but I hate doing it. So I like to avoid it by keeping you guys on it. Okay. So chapter 11 and chapter 12, we'll go ahead and jump into that very briefly. Chapter 11 talked about the main objectives of cross-examination. And chapter 12 just talked about recognizing the objectives of cross-examination. So remember, this entire class is about essentially it's a how-to on how to be a witness. How the rules for being a witness, just the kind of unwritten rules, like telling the truth. Hold on, that's Jalen Brumby. Yeah, but it's like the unwritten rules for telling the truth, right? For testifying. Number one, telling the truth. Not testifying to anything you don't have personal knowledge of and stuff like that, right? And it's talking about how to be credible. Essentially, your job as a witness is to tell the truth, and to tell the truth in a way, or to act a certain way where you are also credible. So it's not just about telling the truth, because you can tell the truth, but still no one will believe you if you're not credible. So it's about telling the actual truth, and then it's also about credibility. So we've talked about that. But as a witness on the stand, up until before chapter 11, all we talked about was essentially, I got you, Jalen. Yeah, all we've essentially talked about is all we've essentially talked about is direct examination and preparing for direct examination. So that means it's been all about being questioned by the attorney that's calling you and just doing your job, which is coming up there and telling the truth. The cross examination, on the other hand, is a different monster. That's when you're now going to be questioned by the opposing attorney. So, being an attorney, a lot of times it's not necessary for me to always have to give a cross examination where I'm trying to really dig into somebody's stuff. Sometimes a cross examination, especially if a person is telling the truth, even if the truth hurts their case, they're just keeping it real. I don't have to really dig into them for cross examination. I might get them to repeat some stuff they already said just to get it out there again. But for the most part, if a person has already said things that help me out, I'm not gonna dig into them. I'm not going to try to damage their credibility. So, as an attorney, or whether I'm a prosecutor or a defendant, my job is to get the truth and the facts out that help my case the most. If those facts come out with during the other side's case where they're direct examining a certain witness, At that point, all I have to do in my closing argument at the end, and we talked about how how the closing argument surmises everything. All I have to do is talk about how the other side's witness said what I'm saying, right? What I believe happened, or said something that helps my case. So on cross examination, when I'm questioning that opposing witness, they've already said things to help me out. At that point, if they've said things that help me, I'm not going to ask questions that are going to attack their credibility. So it's all tactical. In certain situations, I want the other side's witnesses to be credible. I'm like, they said what I like. They said stuff to help me out. They're keeping it real. I'm not about to make them look crazy up here, because if they look crazy and they're saying something I like or something that helps me out, that means it would hurt my case to make them look crazy. So either way it goes, no matter who you're called for, it's still your job just to tell the truth. And I think there's been a question on it was a question on the prior quiz whether it was unethical for a witness for a certain side to want that side to win. And there's nothing unethical about that. Now, it is unethical if you're willing to lie and withhold the truth in order to make that happen. So you can be rooting for the prosecution as a prosecuting witness, and there's nothing wrong with that. But you still have to get up there and tell the truth, even if it hurts the prosecutor's case. So your job as a witness is first and foremost to tell the truth. So on cross examination, you're if you're not helping the opposing side in what you said, you're more than likely what's going to happen is your credibility is going to be questioned. So it may be the credibility of your perception, whether or not you even saw what happened. What was your vantage point if you were an eyewitness, right? What was your vantage point? Are you sure you saw it? Was there anything in the way when you saw it? So you got the vantage point or your ability to perceive. Then they may attack whether or not you have a reputation for truthfulness, whether or not you're telling the truth now. That's why it's important to always tell the truth, because and it's also important to tell the truth and to make sure that the truth you're telling is consistent with stuff you've already said. Like, you may have written a report. Some of you guys will be police officers. People don't realize a large part of being in law enforcement is not just making arrests and going home. When you make arrests and you have cases, you have to type up a narrative. So there's a lot of writing that goes into it. You got to tell us what happened, who arrived, what time, and all this stuff. So a lot of times, so when you're writing that narrative, right after the crime took place or right after you witnessed something and had to arrest someone, you're writing that narrative right afterwards, right? Or pretty soon afterwards. So that's that's pretty much what we call a present sense impression. So you're writing what just happened right after it just happened. So it's fresh in your mind, right? So later on, if you're writing something, if you wrote something and then later on in court, you say something different from what you wrote or something that opposes what you wrote, then at that point, that's what we call a prior inconsistent statement. So you made a statement beforehand, closer to the time, and that statement should probably be relied on more than what you're saying now because it was closer to what happened. So now we're going to you're gonna leave yourself open to be impeached. That means now I'm going to question. I'm going to question you, and I'm going to challenge your credibility. So essentially, you either look like a liar or someone that doesn't have a clear knowledge of what happened. So you're mixed up. Either way it goes, and really I think being a liar is way worse than being mixed up. So, but both of them don't help the case. So if you look mixed up and like you're not sure and like you don't know what you're talking about, then that hurts, of course. That goes against your credibility. But if you're caught lying or you look like you're not telling the truth, I think not only does that hurt the case and hurt your credibility, but it also affects your reputation. So tell the truth and know what you said beforehand. Know about your whatever narrative you had to give or report you had to write. That way, when you get up there, because you're allowed to refresh your recollection anyway, especially as law enforcement, because law enforcement they interact with people all the time, right? They make the average law enforcement officer might make 1 or 2 arrests a day, and they have to write reports, right? So if you think about it, a year or two may go by before the law enforcement officer even has to go to court to testify about it. And in that year and a half, they've probably encountered thousands of people, right? And probably made hundreds of arrests and had to do hundreds of narratives. So in that midst of, the court is not asking this law enforcement officer to now come to court and not be able to use the narrative. They're not, don't have to come off the dome and kind of remember what happened. They're allowed to use their report they wrote close in time to what happened. So they're allowed to do that to refresh their recollection. So that even gives you more reason not to deviate from what you've already, the narrative you've already given. So why would you have the narrative in front of you and still say something different from the narrative? And cops actually do that. It baffles me when they do it. I'm like, bro, you got it right in front of you. Why would you have said something different from what you already wrote down? And I think I might have even told the story during my lecture of the time I had a DUI trial where the cop, they had this standard DUI form they fill out, kind of like their narrative form. And in the form, of course, because in DUIs, of course, everything a DUI suspect does is now under suspicion, is being watched, and it's being used. It can be used against them. So whether or not they have slurred speech, so their appearance, how they talk, their eyes, whether they're bloodshot or glassy, their balance, all this stuff, whether there's an odor of alcohol coming about their person, all that stuff can be used against them right at the scene to develop probable cause for the arrest. But then in court, it can also be used to help bolster the case. In other words, help prove beyond a reasonable doubt that this person was intoxicated while driving. Right. So on this form, they have a place, where it talks about the defendant's appearance, or the defendant's appearance, how they looked, whether there was an odor of alcohol about their person. So this cop on this form, on this standard form that he probably has to do for every case, he didn't leave when it said it asked the question, did the defendant have an odor of alcohol emanating from their person? And the cop didn't leave it blank. He said none. He literally filled it out, none. It was in his, and as a matter of fact, it was even in his handwriting. It wasn't even typed. It was in handwriting. So then he gets to court, and the DA is asking him whether or not there was an odor of alcohol about my client's person, and he says yes, there was. Matter of fact, I think he said there was a strong odor of alcohol. So at that point, I'm looking at the form. I'm like, we got him. And I don't know why he would have said that. He had the form right in front of him. So he said that, and of course, in front of the jury now, I get to open up that can on it and get to say, well, you just said this 5 minutes ago, but then this happened that night. Why? So just 5 minutes ago in front of this jury under oath, you just said that my client had a strong odor of alcohol. But on this form that you filled out that night, you're saying he didn't. So which one is it? And even if he does say, well, it was what I said today, he still looks crazy because he's now testifying a year or two later about something that he actually gave a statement on that night. Like, as a jury, which statement are you going to believe? So you walk away feeling like whatever he said earlier about my client at all is not believable. And then even if it is, we at least don't think he knows what he's talking about, or has a good recollection of what happened, because he's mixed up. So either he's a liar or he's mixed up. So on cross-examination, you want to be consistent. Before court, you want to make sure you look at those narratives that you stated. Don't try to go in there and say, I think I know it all. If you had a narrative that you did the night of, how about looking over it again? If you're in law enforcement, or you might have given a statement, not even as a law enforcement officer, but as a lay witness, someone that was just an eyewitness that happened to see it, and you were questioned. If there's ever a time where you can get your statement that was taken, you might want to get that, or ask for it, or try your best to remember, because if there are things that are inconsistent, that's what opposing attorneys are looking for in cross-examination. When you give them inconsistency, they're going to harp on that and ask you questions about that, because once they get that inconsistency out there, they can chip away at the case. Now, if you're especially defense attorneys, because remember, the burden of proof is on the prosecutor. So the prosecutor is sitting here trying to build this cake, or build this house with these bricks, right? And as a defense attorney, I'm either chipping away at the bricks and trying to show that, trying to weaken the foundation, or even if I'm not trying to push the structure over or weaken it, if it is weak, I'm trying to show the jury where it is weak. Like, look at this, it's a crack in this case. It's a crack right here. This isn't a sturdy wall. You can push it right over. So of course, when you have inconsistency in your case, and as a defense attorney, I can show the jury, in front of the jury, that the case that there are inconsistencies there. That's reasonable doubt right there. So that's why it's important that you come to court and like tell the truth first and foremost. Never get caught lying, because it could come back to haunt you, because you're gonna get cross-examined. And then sometimes you can even get cross-examined because someone else that was a witness at the scene said they saw something differently, right? You kind of can't control that. All you can control is your truth and what you said, and what you're coming to court to say. You can't really come to court, even if someone else said, "Well, I didn't see that. I saw it this way," and their witness, it kind of is what it is. Now it's kind of witness versus witness, but at least you're not a liar. There's nothing inconsistent about what you said. So that's cross-examination. That's what they're going to do. They're going to challenge your perception, like whether or not you were able to see what you said you saw, or perceive what you said you perceived. Then they're going to also challenge your credibility. So that's the two main things: perception and credibility. So the book talks about some more things, but those are the two main things: perception and credibility. So you have to be prepared to be cross-examined. There's nothing to be scared about in cross-examination. It's just like direct examination, except the questions are going to come differently. They're different rules. The questions can now be leading questions. So the questions are going to come at you different, and there's a different set of rules that apply to cross-examination questions when it comes to an evidentiary, the rule basis. So if you know the truth and you're there to tell the truth, no matter who's asking you a question about the truth, you should have the same answer. So just remember that. Be consistent in your answers, and come to court knowing what you've already, at least come to court knowing what you've already written down, at least. Even if you don't necessarily remember everything, at least know what you wrote down already, and what statements you already made. So those are some of the objectives of cross-examination. So we also have cross-examination objectives, and what I call theories of the case. And normally in this class, before, when we were in person, around this part of the semester is when I would be breaking you guys up into groups, and you would be doing, for this class, I assign each group a case, a real case in real life that happened. Usually it is a famous case, like a famous person that was, like the Michael Jackson trial or something like that, where you have to look and tell me who the litigants were, and what their theories of the case were. So we always know what the state's theory, we always know what the prosecution's theory of the case is, right? We know that they're saying this person's guilty and they did it this way, they did it, right? But sometimes it's important to notice what the defense's theory was. So in other words, what is their defense? What are they saying happened? Or what are they saying to assist their client? What is their client's story? What's the story they're trying to tell? That's all the theory of the case is. So the book even talked about those theories. I think it talked about somebody else did it. The SO, what's that? What is it? This doesn't apply defense. I think spaghetti defense and stuff like that. Some other guy that, the SOG, some other guy, and that's usually alibi. So you talk about the book talks about those different theories of the case. So I would have had you look at these cases, read or whatever, and then give a report to the class, give a written report to me, and then present to the class, and tell us about the case, what the theories of the case were. So I would give you I will give you the opportunity to take what we learned in the reading and to see if you can apply it to real cases and figure out, okay, what was the attorney in this case trying to do? Who was the witness they were going to use to do that? So stuff like that. It's usually pretty fun for this class, but of course, with everything that's been going on with the quarantine and virtual learning, I'm just not to the point where I'm comfortable trying that in this environment right now. It's hard enough getting people to work in groups when they are here in person. So you guys are all over the place, and having to do everything virtually. So I know it'd be impossible to do real group work in this situation. So I kind of had to X that out. but I do want you guys to recognize these theories and stuff like that. So that's 11 and 12. Now 13 is kind of the wrap up. It kind of ties everything in at the end. But the way the schedule went, I just put it in by itself. So chapter 13, I think the lecture on chapter 13 is very brief, but it'll be up in the morning. So go ahead and read chapter 13. I think it might be 7 to 8 pages or something like that. Read that chapter, and like I said, at the end of every chapter, remember the book has those review questions. And I told you before, and I'll say it again. That's where I get my quiz from. So the quiz for this section of the book is going to come from those questions. I'm not going to deviate, so I'm going to pick 10 of those questions and put them on the quiz. So if you're reading the chapters, and at the end of every chapter, you're looking at those review questions and looking at the answers and knowing and figuring, and because that means the answers on my quiz are going to be the same. Now I'm not telling you which questions, but that's where I got my questions from. So you have my question bank. So that ends the text. That chapter 13 will end the textbook. So next week we'll have let me see. Yeah, next week we'll do a Zoom discussion, and then that next day, quiz 3 will be up. So we'll kind of do a brief review. I'll talk about the quiz on next Thursday. I'll talk about chapter 13, and I'll talk about the quiz. And then we'll talk. And then next week, I'll be here on Zoom, but we don't have a Zoom. But that's the week after that. That'll be so next week is the 22nd, the 29th. Now I'll announce it. I know you're not gonna remember now. But let's just go week by week. So this week coming up, chapter 13, read chapter 13, look at my lecture on YouTube, and then we'll meet on the following Thursday, the 22nd, to discuss it. So the 22nd, we're going to discuss it. And then on the 23rd, that Friday, quiz number 3 will be up until Monday. So just want to make sure you guys prepare to know where to get stuff from. And then so we're officially done with the book after the quiz. So then I also have things that I put up in the learning modules. So I there should be so there were 2 cases you needed to read over, and I put those cases kind of the Wikipedia format of the cases kind of tells you what's going on. So it's not really the actual case; it's printed out. But it's a good synopsis of the case. So read over that so you know what's going on and know what we're talking about, understand the gist of it, and then look at my my lecture. My lecture will go deeper into what the cases mean. So they're very important things we learn from those cases because we learn about certain rules of evidence. I think we already talked about relevance in one of my earlier on in one of my lectures, right? First, all testimony and all evidence must be relevant, meaning it either tends to prove or disprove something having to do with this case or with the facts at hand, not anything outside of it. That's the number one rule. And we're going to learn about another rule called the hearsay rule. We'll talk about what that is, but we're not doing that tonight. So any questions before we log off? All right. So that's chapter 11 and 12. I'll see you guys next week. And now when I'm posting these Zooms, I'll post them for a purpose. So even if you don't show up, you're not gonna get credit for being here if you weren't here. But I'm still trying to give everyone the opportunity to not miss anything that I say. So has anyone had to click or look at the Zooms that I post when I post the Zooms on YouTube? Has it been helpful for anybody that's had to use it, or has everyone just been here?
Okay. Yes, it's been helpful.
Good. All right. So that's what I'm trying to be helpful. I'm trying to give y'all every resource and make sure there's no excuse. I want to make sure I'm not leaving anyone behind. Okay. Thank you, Kyla. All right. So you guys be good until next week. Y'all guys take care, and I'll see y'all next Thursday. For some of you. Oh, also, there's going to be another extra credit opportunity. So right now we're in the planning stages. We're probably going to do not even probably, it is going to happen. There's going to be a student panel, and there's going to be an opportunity for students to talk about the Breonna Taylor case. So we're going to have maybe 3 or 4 students that are going to be panelists, but I think you guys, the students, are going to have an opportunity to be heard, to ask questions if you have them. So the first panel is going to be, I think it's going to be Wednesday, next Wednesday. It's probably going to be at 7:30. So it's I think matter of fact, I think I'm moderating it. So it's going to have to be after my 6 o'clock Zoom for that Wednesday class. So it's going to start at 7:30. So I'm probably going to give extra credit, 5 points or so, for you guys signing on and being in there. And like we did with the last one, just send me a direct message saying I'm here. I'm on here. So just be on be on the lookout. That means I'm going to post it. I'm going to also post the Zoom link and everything. Oh, thank you, Kyla. So you guys be good. So just be on the lookout for that. And that's it. So y'all take care. Be good.
All right, you too.
All right.